Welcome back to the Friday Five for August 11th, 2023. My name is Andrew Ayers. I'm a business law and estate planning attorney with offices in Edina, Minnesota and New York City. Today we're going to look at 5 quick questions from the week that came up in discussions with clients and prospective clients, and maybe you've had these questions before too. We'll give you some quick answers and get you on your way for the weekend. Question number 1 this week: is it a long process to reinstate my business? Now, the typical lawyer answer is always going to be, it depends. Why was your business dissolved? If it was dissolved voluntarily because you were just going out of business, that's one thing. If it was dissolved because you didn't pay your taxes and licensing fees to your state, that's a completely different thing. So let's assume it's the latter, that we didn't pay our taxes, we didn't pay our fees. What we have to do then is talk to your state where the business was incorporated and find out what it will take to get the company reinstated. Normally, this will mean you're paying back the taxes and the other fees that you were supposed to have paid over the years. And once that is all done, they issue a letter, a tax clearance letter usually, that says that the business has paid all of its back taxes, it's paid all of its fees, and now it can be reinstated. You take that letter then to the Division of Corporations in your state, and you file the paperwork, and it can be reinstated. So how long it's going to take is really going to depend on how long it takes you to catch up on all those filing requirements. If you didn't have that situation, if you just voluntarily dissolved your company, but you want to restart it, it's usually as simple as calling the State Department of Division of Corporations and finding out from them what needs to be filed. Usually it's just a simple form. You file it, you pay your annual fee, and your business is up and running again. Question number 2 this week: can I sell my business if I don't have an operating agreement? This is a very common situation that I run into with clients. They've set up their company, they've got it running, everything's going great. Maybe now they either want to sell it to somebody else or bring on a partner, and they realize, wait a second, I never took the time to get my operating agreement in place, or my shareholders agreement, or my ownership agreement. So depending upon the type of company, there's all these different types of agreements that you can have, but the main one is your operating or your shareholders agreement that says what happens, who are the owners, and gives a process for these kinds of situations. So you can sell your business without an operating agreement. However, what you need to do then is find an attorney, because you need to understand what the laws are in the state where the company is formed regarding the sales of business. The advantage of having the operating agreement is you can take that process and lay it all out in the agreement for how you can sell, what the value of the business would be, who's entitled to buy your interests. So what it does is it takes that law and makes it streamlined. So if you don't have an operating agreement yet for your business and you think you might sell it down the road, let's make sure we get one in place for you. Question 3 this week: can I manage my rental property without an LLC? So in this case, the prospective client has been working with a management company for years who's been managing the property. He's no longer going to work for that management company, and he owns the property in his name and wondered, is he legally allowed to be a landlord when someone else has been the property management company? The simple answer is yes, you absolutely can. It's your property. You can work it out however you would like. You don't need an LLC to own your rental property to be able to rent it out. You can always have a person-to-person, an individual-to-individual rental agreement with your tenant. But you may want to look at whether it's a good idea to put that property into an LLC for your personal protection, because if you personally are renting that property to someone else personally and something happens, you may be the one who's sued. Question number 4 this week: can my trust own out-of-state assets? And you need to look at your local state where the trust is set up to figure out for sure if they can do it. But usually, yes, your trust can own out-of-state assets. And this is one of those estate planning vehicles we use so that we can save our estate the problems in working with a variety of probate courts. So for example, as opposed to having all these out-of-state properties have to go through your local probate court to be divided and distributed to whoever you'd like in your estate plan, the trust can be the one who owns the property, the trust can manage the property, and the trust can then transfer the property to your beneficiaries or whoever you'd like it to go to as part of the trust. And it should help you avoid the probate court in that other state. So let's say, for example, you live in Minnesota, but you own property in Connecticut. What you can do is have the trust own that Connecticut property. And so when you die, instead of having to deal with a Connecticut probate court and a Minnesota probate court, you can use the trust as the vehicle to manage that Connecticut property. And question number 5 this week: can my spouse and I do individual trusts, or do we have to do a joint trust? So this came up in the context of you have a couple with some money and they each want to do a trust, and they have very differing goals for what they want to do with their estate plan. And the question was, can we put it all into one trust, a joint trust, and have everything run through that, or can we do separate trusts? And the answer is going to be It depends on your situation and what you'd like to do. In this situation with this client, what we're going to do is do separate trusts, one for each of them, because they have very specific assets that are not mingled together. Interestingly enough, these clients do not have marital assets, so they don't have anything in joint names. They own multiple houses, each in separate names. They have bank accounts, they have retirement accounts, they have investments, nothing with joint names on it. Now, when you create this scenario, there's a lot of other estate planning that has to be involved, because using joint names can be a very effective way to keep assets out of probate. But for these clients, since they're not going to go with a joint name situation, we want to make sure we have these individual trusts, one for each of them, so that we can keep those assets out of probate and have a smooth transition to their beneficiaries and the other charities they want to work with after they're gone. So you do not have to have a joint trust if you're married, but you need to look at the situation to see whether a joint trust or individual trust makes more sense for you and your spouse. So if you found this video helpful, you can hit the like button or the thumbs up below. You can subscribe to the channel on YouTube. There'll be a link below as well if you want to ask questions for future Friday 5 episodes. And you can always get more information about me at 𝙃𝙀𝙍𝙀𝙀.com. We were off for a couple weeks for vacation. We're back now, and I hope you, wherever you are, have a wonderful weekend.